Session will commence soon.
The Honorable Chief Justice and Associate Justices of the Supreme Court of California, hear ye, hear ye, hear ye. The Honorable Supreme Court, sitting en banc, is now in session.
Recording has started.
Please be seated.
Good afternoon. Welcome to oral argument. We are also having the hybrid use today. Thank you. The clerk may call the calendar.
Good afternoon. The Supreme Court of California hearing oral arguments in San Francisco on Wednesday, December 7, 2022 at 1 p.m. Case number S268480, ARNETTE Travis et al., plaintiff and appellants, versus Bill Brand et al., defendants and respondents, Redondo Beach Waterfront LLC et al., appellants, ARNETTE Travis et al., plaintiff and appellants, versus Bill Brand et al., defendants and respondents. For appellants, Ms. Betty M. Shumener.
Ready, Your Honors.
For respondent, NILS NEHRENHEIM, Ms. Jeanne Zimmer.
Ready, Your Honors.
And for respondents, Bill Brand for Mayor 2017, and Linda MOFFAT, Mr. Stevan Colin. Case number S257631, the People Plaintiff and Respondent versus Heather Rose Brown, defendant appellant. For appellant, appearing by video conference, Mr. David Opolsky.
Ready, Your Honor.
And for respondent, Mr. Cameron M. Goodman.
Thank you. Calling the first matter, ARNETTE Travis versus Bill Brand, Redondo Beach Waterfront, and ARNETTE Travis versus Bill Brand et al. When you're ready, Ms. Shumener.
Thank you very much, and thank you for the opportunity to appear before you today. It's greatly appreciated. The reason we're here today is because the Travis Court parted ways with the Hedgecock Court to find that a prevailing defendant in an action brought to enforce the Political Reform Act need not show that a plaintiff's case is frivolous in order to recover attorney's fees under Government Code Section 91003, subsection A. There were two strains of thought that appeared to run through the Travis Court's decision. The first was that the legislature left it to the discretion of the judiciary to determine the conditions under which attorney's fees would be awarded to plaintiffs under Section 91003A. The second was to liken an action brought under the Political Reform Act to an action brought to enforce the Copyright Act. And in both instances, respectfully, the Travis Court made a mistake. The discretion left to the judiciary is a discretion to carry out the mandate of the legislature in the way that the judiciary sees best fit or most fit. And what is the mandate of the legislature when it comes to the Political Reform Act? Section 81002, Government Code Section 81002 of the Political Reform Act, at subsection F, very plainly states, quote, adequate enforcement mechanisms should be provided to public officials and private citizens in order that this title be vigorously enforced. And the title that is being vigorously enforced in Section 81002F is the Political Reform Act. It is not simply left to the discretion of the trial judge to say, oh, I think this time I'll give it to plaintiff, this time I'll give it to defendant. The discretion is to set a standard that will promote the goals of the Political Reform Act. And the Travis Court failed to do that, failed to apply such a standard. The Travis Court...
If I could interrupt in terms of the standard, is there anything actually in the text to describe what standard we should apply in determining whether plaintiffs and defendants should be treated the same?
No. The language, just as in Christiansburg, just as in the Copyright Act, just as in the Political Reform Act, the statute is very plain vanilla. It says the court may award to a plaintiff or defendant who prevails that party's costs of litigation, including reasonable attorney's fees. And the focus has been that when the legislature uses the word may, it is indicating to the judiciary that the judiciary is in the best position to set the standards. If the legislature had simply wanted whoever the prevailing party is shall recover attorney's fees, it could have said so. Prevailing party shall recover attorney's fees. And it expressly did not do so. The second mistake that I believe the Travis court made was to liken the plaintiffs and the defendants, the parties in a Political Reform Act case, to parties in a copyright case. Well, there's a number of problems with doing that. First, parties to a copyright case have self-interest involved. There's self-gain. There's adequate motivation in a copyright case for plaintiffs and defendants to be fighting over who owns this asset, who owns the copyright, who will have the control as to where this piece of art or where this musical piece will be played and displayed. And it's self-gain, it's self-interest. And whether the plaintiff in a copyright case wins or the defendant in a copyright case wins, the result is the same. The Copyright Act has been enforced. And in a Political Reform Act, the goal is there's no self-gain for the plaintiff. The goal is disclosure. The goal is to ensure that the voters, that the public, have enough information about the agendas and the affiliations of political action committees, that they have enough information about where the money is being raised for political candidates so that the voters can make informed decisions.
What if there were some type of evidence of a monetary interest that existed? How would that affect your argument?
Monetary interests it would not affect my argument, because the purpose of the Political Reform Act, the disclosure, even if there was monetary interest, the purpose is to further disclosure to the public. And that is a goal that can be achieved only by the plaintiff. The defendant does not enhance or further disclosure or increase the disclosure to the public if he or she or it prevails. It's only the plaintiff who prevails, who manages to increase the information that is disseminated to the public in the voting process. Now, the court in the Hedgecock decision recognized these factors and recognized that a Political Reform Act, an action brought under the Political Reform Act, is much more akin to an action brought under the Civil Rights Act. That each is, in each instance, just as the legislature wants private citizens to vigorously enforce the Political Reform Act, Congress weaponized or used plaintiffs as their weapon to enforce the Civil Rights Act. And in the Civil Rights Act, Hedgecock was frankly brilliantly decided, because Hedgecock is looking at the situation and saying, boy, a plaintiff in the Civil Rights Act, it might not be going there for monetary gain, but he or she is certainly going there to vindicate a right and some wrong that had been perpetrated against the plaintiff in a Civil Rights Act. A plaintiff in the Political Reform Act case has no such interest. He or she has not been wronged. He or she simply looks and says, these people, I don't believe them. There's evidence to suggest that the ROPAC first filed papers saying it was a special purpose entity, tying itself to Measure C, later filed other papers saying it was a general purpose entity. Brand and ROPAC raised funds together. One bought advertising for the other. They felt there was not adequate disclosure, that there were control issues that had not been adequately identified to the public and that the public was being misled. Now,
should we be concerned? There is sort of lurking, perhaps not lurking, but it's seen an assertion that that it was the developer itself that sort of is behind this litigation, for lack of a better word. And if we should be, how does that work into our evaluation of whether or not the CA got it right here?
It is false that the developer was behind the work. And what is, I happen to be in possession of certain facts regarding that, but none of that is on the record. And what troubles me is that the only thing that is in the record is that the developer was willing to fund the plaintiff's attorney's fees. What the problem with finding frivolousness or some misconduct on that basis is it will leave the enforcement of the Political Reform Act to the rich. If some citizen, and these citizens, it's even stated in the defendant's papers, the plaintiffs in this case are civic-minded, active citizens. They show up at city council meetings, they make objections to some of the agenda items. One of them even ran for office against Mayor Brand. So to sit there and say that these people are shills because they weren't rich enough, because they didn't have enough money to pay for the legal fees that it would cost to bring the Political Reform Act case is simply wrong. And I will tell you what is almost entertaining in this instance is if you stop and think, was it a loan that the developer made to the plaintiffs to fund the litigation? Is there interest accruing on the loan? Was it a gift? Who solicited it? Who asked for it? Who brought it to the attention? You have a lot of accusations, a lot of innuendo, and not a shred of evidence. The only evidence that was before the trial court on the very last day of the case was to compel the plaintiff's attorney, improperly I might advocate, was to compel the plaintiff's attorney to take the stand and answer the question, who paid your legal fees? Who cut that check? And that, one, is irrelevant, should not have been considered at all, and two, is not evidence of an action being frivolous, and certainly is not evidence of two conscientious citizens who have been politically active in the city of Redondo Beach for years, as evidenced by the statements made in the defendant's appellate brief, okay, should be called insulted and called shills because they couldn't afford to pay their own legal fees. And I submit that is just wrong on so many levels. Contingency fee plaintiffs should then be held to be shills. Anyone who goes to any group and says, I need to raise money, I got to bring this action, I don't believe these people made full disclosures, help me. Okay? Why is it that only political candidates get to raise money? Why is it that only PACs get to raise money? It was just wrong. And in this instance, what was so wrong was to find frivolousness at the end of a case on the basis of a sentence from plaintiff's counsel that his legal fees was paid by the developer, okay, is particularly disturbing. In this case, 5 motions for summary judgment were brought to the trial court. The trial court denied every motion, and not just with a mantra, oh, material issues of fact are in dispute, but actually went through and said, having reviewed the plaintiff's declarations, having reviewed the exhibits that were submitted, having looked at the separate statements, and most importantly, having looked at the deposition transcripts of the defendants, their testimony, I find tribal issues of fact as to whether there were adequate disclosures regarding who controlled the committee. And that is in the minute order entered, the index is pages 108 and 109. But the defendants didn't stop there. The defendants brought a motion to dismiss before the trial started. Again, the judge found, nope, there's merit here. Case goes to trial. The plaintiff put on its case, brought witnesses to the stand, introduced its exhibits, went through a few days of its presentation, rested the case. At that juncture, the trial judge had before it the entire plaintiff's case, everything there was to know, from what the plaintiff's basis, what the evidence was. The defendants made an oral motion to dismiss. Denied, said the trial judge. You need to put on your case and overcome this evidence. The defendants then brought a motion for non-suit, a written joint motion for non-suit. Again, after the plaintiff's case had rested, you've got the whole case before the court. Denied. Defendants put on your case, overcome this evidence. Probable cause was found by this judge no less than 8 times.
Ms. Shumener, perhaps you can clarify this for me. I follow your argument to understand that this particular attorney fee cost provision is within the trial court's discretion to effectuate the purpose and intent of the legislature. And as you answered Justice Guerrero, the language of that provision 91003A is a discretionary prevailing plaintiff or defendant. Here, of course, the issue, it appears to me, the issue you are most, and I don't think you take issue with that. You're indicating that there was basically improper, inappropriate, I think, insufficient evidence to make a finding of frivolousness such that plaintiffs were denied attorney fees. What factors do you think should go into a court's discretion in weighing then whether or not attorney fees should be awarded to a prevailing defendant or plaintiff?
Whether a plaintiff acting as a reasonable person had sufficient evidence at the outset of a case to decide, because do you have evidence that there has been that one group is controlling another? Do you have evidence that ROPAC was a specially formed committee? Sure. There was a form filed by ROPAC itself saying it was special purpose committee. Do you have evidence that Brand, NEHRENHEIM, et cetera, controlled ROPAC, influenced ROPAC? Well, they had funding events together. Brand, I believe, took out advertisements for ROPAC at certain points. And even with ROPAC, was it a special purpose committee? Was it a general purpose committee? The majority of the funds that ROPAC spent, of its monies, went to Measure C, went to promoting a certain ordinance showing that it was special purpose. Now, there's no certainty in litigation, and you certainly don't have all of the facts at the outset of a case. But if a plaintiff at the outset of a case has a reasonable basis to believe that adequate disclosures were not made, the legislature wants those plaintiffs, those private citizens, to vigorously enforce the Political Reform Act. Vigorously.
The focus only at the initiation of the litigation, or rather continuing to prosecute after it becomes clear that your case lacks merit?
No, it's the latter, Your Honor. Thank you. It's both at the initiation and the case should be abandoned if evidence turns up that would show that the case was frivolous. But none of that occurred here because, and as we know from the fact that after the plaintiff rested its case, the judge wouldn't dismiss it. And how can you say that it's frivolous, that there's no evidence, that we should have known? It simply, it doesn't hold up. So with that, I thank you, Your Honors. I've saved 10 minutes for rebuttal. Thank you very much.
You have those minutes. Thank you, Ms. Shumener. First, Ms. Zimmer.
Thank you, Your Honor. Jeanne Zimmer on behalf of NILS NEHRENHEIM and all respondents. May it please the court. We're here for a very simple issue today, and that is regarding the statute and whether or not Government Code Section 91,003, Subdivision A, means what it says and says what it means. And it is the respondent's position that the simple, plain meaning of that statute, which is what the court needs to look at, is that, and I quote, the court may award to a plaintiff or defendant who prevails his costs of litigation, including reasonable attorney's fees. That's what the statute says, and that's what the statute means. The Travis court...
That can't be the end of the analysis, can it?
No, Your Honor.
May is a term that seems to import circumstances may dictate.
Absolutely.
Which party gets fees. So we have to drill a little deeper, don't we?
Yes, Your Honor, absolutely. It's discretionary.
Arguing a plain meaning.
The point...
Is that what you're arguing? The plain meaning of the words in the statute dictate the outcome?
I'm arguing that there's no ambiguity in those words, Your Honor, so we don't really need to go much farther. But I'm also arguing that it absolutely says may, and it's discretionary with the court as to whether or not the attorney's fees will be awarded. But that's in the discretion of the trial judge.
Is it unbounded discretion, bounded only by the realm of reason, or are there particular guidelines that a court must take into account, particularly in these kinds of cases?
Well, there's the Hedgecock case, which respondents respectfully believe was improperly decided. And in Hedgecock, it was a strange situation where Mayor Roger Hedgecock in San Diego was facing criminal charges by the DA as well as civil charges under this code section, 91,003. And there was an agreement between the FPPC and the DA that the DA would dismiss the civil portion of the FPPC, the charges under the Government Code Section 91,003A, and that the DA would proceed with the criminal case. So Mr. Hedgecock decided, well, I was the prevailing party then on the case that the DA dismissed, the civil portion of it, which really wasn't the case because he was still facing those civil cases. It's just that the FPPC took over.
The court didn't decide the case on that ground. In fact, it explicitly says we're not deciding the case on that ground.
I understand, Your Honor, but that's where I have an issue. And that's why when Travis came along, Justice Wiley and the Second District did look at that and said, this is not how we want to hold in Travis, because they looked at the Fogarty case, Your Honor, which is the Copyright Act case, which Ms. Shumener discussed. And the situation in our case, as in Fogarty, is different than Christiansburg and the civil rights cases, and is different than...
Does the purpose of the legislation play no role in determining how discretion should be exercised with respect to the award of fees?
Your Honor, it plays a role, and the policy...
Would that discretion then be at least consider the animating purposes for the statute?
I think it can be considered, Your Honor, but I also think you still need to look at what you have to give some leeway to the trial judge. And our judge saw all of this, looked at all of this, and felt that there was, well, excuse me, let me back up. The frivolousness issue comes in later. I believe that you can, of the way that the statute is written, is that you can just look at that and you don't, there should not be another hurdle for a defendant, because it's not in the statute.
Can I focus on, counsel, that point that you've mentioned that a few times, and you're focusing on the word may in the Political Reform Act. How does that differ from the statute that was at issue in Christiansburg? Didn't that also use equivalent language, may?
Yes, Your Honor, but it's a whole different situation because I think the issue in Christiansburg was the relative strength of the parties, for lack of a better word. It's in a civil rights case or in an employment case, you have an asymmetrical attorney's fees provision where if a defendant prevails, the defendant has this extra burden to prove frivolousness and groundlessness. Because an employee suing an employer is in a different position, or a tenant suing a landlord is in a different position. A civil rights plaintiff is in a different position. They don't have the bargaining power, they don't have the resources that on an equal footing. And in our situation, there is equal footing. In fact, if there's more resources in our case, it's on the side of the petitioners. We have a retired stockbroker, we have our CTO, Chief Technical Officer of a company, being funded by a major developer, as opposed to the respondents. We have a retired airline employee, we have a lifeguard, we have a real estate agent, and we have a stay-at-home mom.
Are you aware of any case that has raised the question of how to understand the standards that govern attorneys' fees, where the answer has been to look at the particular financial circumstances of the litigants involved?
Well, I think Fogarty discusses that a little bit, Your Honor, and it talks about in there where the both parties on either side in that case really are kind of on equal footing, and that's why they don't apply the statutes asymmetrically. When there is a prevailing defendant, they don't add another burden to them.
But isn't it so that in Fogarty the description of the equal footing relates to the act, the Copyright Act, not the people? It's that they say somebody successfully defending a copyright claim vindicates the act just as much as a plaintiff prevailing. It's about the act, not the people. Isn't that right?
Well, Your Honor, but you have to look at why. I mean, here, the act, the candidates in our case are trying to also, I mean, their First Amendment rights, they need to be able to provide to the electorate, to the voters, their position on things such as development in the community. And that's what they did. And the electorate appreciated that, and they voted for them. In fact, both of these, the mayor and the council member, were just reelected this last March. So obviously their position, they're allowed to tell everyone in the community under First Amendment regulations that this is our position on things. And their First Amendment rights would be, subjugated if they were not allowed to do that. And if they faced an additional burden to prove more than a plaintiff would have to. And practically, I mean, we did show frivolousness at the trial court level. The judge, in his discretion, found that that the action was frivolous. So in a practical sense, even, there's still attorney's fees that have been awarded because we have met that burden, but I don't think it's necessary to meet that burden.
You make of your opponent's argument on that point that the judge made that judgment for the defense after hearing all the evidence. He did not, at the close of the plaintiff's case, say, "Oh, this is a no-brainer. This is clearly frivolous, and I don't need to hear anymore."
Your Honor, I think that judges in their, I've tried some cases in my time, not enough, but some, and the judges love this to go to the fact finder. They don't always, it's difficult to get a summary judgment granted. It's difficult to get a non-suit.
Well, we should tread lightly here.
It's just how it is. They don't want to be in front of this esteemed court and be overturned on certain things, or in front of an appellate court. So they like to let everything go to the fact finder, whether it be a jury or the judge. But I think that there is a difference here that's not found in those civil rights cases, and that we really just need to look at the statute and the plain meaning of the statute. And that in this case, that those attorneys' fees should be, that they should be allowed, as they have been, and that we should.
I want to give you a chance to help me understand one thing that's holding me up a little bit. When you say these kinds of cases are not like the civil rights cases, because the civil rights cases exist to vindicate essential rights that might otherwise, for any number of reasons, not be amenable to litigation. And so it makes sense to have a different standard for the civil rights cases, or an employment case.
Yes.
But don't these kinds, the kind of suit involved in this case, doesn't it also function to defend truly essential rights of the electorate in a free society? The right of citizens to challenge their their governmental decision makers. That seems like it's pretty important. Why aren't they this? Why aren't those three categories the same?
Well, because, Your Honor, in cases like we have, the plaintiffs brought the action, and the defendants had to defend that action. But where a defendant does, it's also the rights of the defendant, and where the defendants are successful and prevail, then why do they have to have a different, excuse me, repeating myself a million times, why do they have to have a different standard? I don't think that it's appropriate.
But that's my question. If we say, and you seem to acknowledge, that it is okay to have a higher standard when the rights at issue are either civil rights or employment rights, but political rights of the electorate vis-a-vis their elected officials aren't quite as important. And I get it that you want to argue for discretion, and you were entitled to, but that doesn't really answer the parity of the kinds of cases. And if you want me to treat them differently, I need you to explain why these rights in the political arena are not as important as the other rights you seem to concede are more important.
Because the defendants also have rights of free speech. They also have rights that they are allowed to make their positions known. And when a prevailing defendant in a political Reform Act case does prevail, he has as much right, a candidate for office has as much right to go out and tell his position as people who are challenging it. And he should not have to have an additional burden. These people don't have the wealth or the means to challenge this. They've gone through this for almost 5 years with nobody paying for them to go through this, and why should they bear that burden?
Well, is that what the trial court should do? Let's just see who's got more money on which side?
No.
And if you turn out to be on the rich guy's side, you don't get your fees even though you prevailed? Is that the way the standard ought to be applied?
No, Your Honor. But I think it's not fair to say that only plaintiffs in these cases just would get their fees as a matter of course, and that defendants have to do something more. That's not what the Political Reform Act requires. And as far as policy, I think, and the legislative intent, Mr. Colin is going to speak a little bit more to that. So if I'm ready, I can, unless there's any other questions, I'm going to turn it over to him.
Thank you.
Thank you, Your Honor.
Thank you, Ms. Zimmer. Mr. Colin, 15 minutes, sir.
Good afternoon, Your Honor. Stevan Colin on behalf of the respondents, Bill Brand for Mayor 2017, and Linda MOFFAT. I wanted to mention one thing that's in the record that hasn't yet been discussed, and that is that at the trial, there were 11 witnesses who testified. And one of those witnesses for the plaintiffs, the petitioners here, was Ann Ravel, a former member of the Federal Election Commission and the former chairwoman of the FPPC. Okay? The FPPC, an organization that was formed when the Political Reform Act was approved by the voters back in 1974. And in her testimony at trial, she stated there was nothing that the respondents did that was illegal. And in argument, Mr. Hertz, the former lawyer for the petitioners, said there was nothing wrong that they had done. So that is a consideration of Judge Mackey and the testimony of all the other people who came, including Amber Maltby, who was the expert witness for the defendants, respondents, who said there was nothing that they did that was illegal. And the judge specifically found in the judgment and in his orders that our clients had acted in good faith and that the people had voted along with our clients in the election. And Judge Mackey also found, and these were his words, not the words of counsel, that the plaintiffs were shills in a sham lawsuit. Those were words spoken from the judge, not suggested to him. Let me get to the Political Reform Act of 1974. That was an initiative that was drafted by then Secretary of State Jerry Brown, Common Cause, and the People's Lobby. And the people voted in June of 1974 to pass that initiative. So this is the will of the people. I believe it was 70% of the voters in June of 1974 who said, this is what we want and this is what we are going to approve, and they did. Section 91,003 was a part of that initiative. And it is clear the language in the initiative in that section is the same today as it was back in 1974. That language has survived for 48 years. And if you look at the original initiative, it doesn't have qualifying language. It doesn't say that a prevailing defendant only gets his or her attorney's fees if they show that the action brought is frivolous or it lacks foundation or that it's unreasonable. That's the finding of this judge who presided over the 5-day trial. Okay? Now, this is a case where it's not good policy to allow the Political Reform Act to be weaponized and to attack people who are engaged in expressing their First Amendment rights. And that's what we have here. Mr. Brand, Mr. NEHRENHEIM, Mr. Craig, Ropak, and Linda MOFFAT. Let me just say about Linda MOFFAT. She is a stay-at-home mom volunteering as the treasurer for the Brand for Mayor 2017 campaign committee and gets dragged into this lawsuit. She wasn't paid. This woman is minding her own business. She's filling out the forms. And I also want to say that the plaintiffs at trial concede that there was nothing done that was illegal. Nothing done that was illegal. So what we don't have here is a robust enforcement of the Political Reform Act. What we have is the Political Reform Act being used to target my clients, the respondents, because of their First Amendment exercise in a campaign setting.
If that's true, though, then wouldn't you be able to readily make the showing of, if it were required, that the lawsuit, when it was initiated, either then or later, was frivolous or without merit?
Well, that's what expert witnesses are for. And at the time that the summary judgment motions were heard by Judge Mackey, there was no testimony of these expert witnesses. But he then heard that testimony, and he heard those admissions at trial by Ann Ravel that there was nothing wrong here. And so based on everything that he had heard, all 11 witnesses at the trial, we didn't have 11 witnesses at a summary judgment motion, but we did at trial.
Mr. Colin, I think I'm having a little hard time following your argument. You seem to be saying that because we won, obviously nothing was wrong. But that's not the standard. I mean, that's the whole purpose of the Political Reform Act, is that concerned residents are able to make the inquiry as to whether and allege that there hasn't been full disclosure, or the funding hasn't been fully disclosed, or this is a general versus specific. I mean, I seem to hear you arguing, well, look, this was the evidence, but then that would seem to turn the whole purpose of encouraging the residents of California to bring this inquiry to keep government honest in a political setting on its head if we were able to look at the evidence. I mean, the way I read the record, and maybe you can help me, the trial court made very few findings to get to frivolousness. Who paid? Who are these people? And I think it's a problem if you consider frivolousness based on who paid. A lot of impact litigation that changes people's lives is paid by people who can afford it. So on what basis did the trial court find frivolity?
Well, let me just say this. Our position isn't we win because we won at the trial level. Our position is Judge Mackey considered all of the evidence. And who better to have access to Ann Ravel than the plaintiffs themselves? They knew what her position was going to be. And yet this injunctive relief action proceeded to trial. And when she got to trial, that's when her admission was made on the stand. I'm not sure that the petitioners would have had her say anything other than what her opinion was. And she said no, and Judge Mackey heard that. But you also have Judge Mackey who's able to consider the credibility of the people testifying. And as we pointed out in our brief, the plaintiffs initially took the position at trial that they didn't know who was behind the funding of the lawsuit. And it was only after their attorney, Bradley Hertz, was called to the stand that the truth came out, that it wasn't these two plaintiffs who were prosecuting the action. It was Redondo Beach Waterfront that was paying for the prosecution of our clients. And once that was disclosed, after the trial had ended in mid-November, on January the 2nd, these plaintiffs, petitioners, submitted declarations to Judge Mackey for his consideration, where they did admit that they had known all along that there was somebody or some entity that was paying for the lawsuit. And that was before Judge Mackey had signed off on the judgment and before he had considered the motions for attorney's fees. I also want to point out that those same declarations were submitted in opposition to the motions for attorney's fees in May of 2019. So it's not because we won, but it's because this judge evaluated the evidence, considered the credibility of the parties, and even made a finding that the defendants, the respondents, were credible witnesses here. That is why he ruled the way he did. So, and the Court of Appeals said, hey, there's substantial evidence to support what Judge Mackey found. And so, do we reweigh all of the evidence, or do we accept what he found? And that was the position of the Court of Appeal. Justice Wiley said, hey, we're not going to reweigh all of this evidence. That goes to the sound discretion of the judge who was present during this 5-day trial.
Well, I don't disagree with you that when a judge is exercising his or her discretion, there are many things that the judge can and should consider, including credibility and other factual questions. But the case here seems to turn on whether or not, having done that weighing, Judge Mackey applied the right standard.
Well, what we do is we look at his 30-page statement of decision, we look at his judgment, and we look at the order granting fees that he signed in August of 2019. We've got 3 documents that shed light on what Judge Mackey was thinking and what he based his ruling on.
Well, did Judge Mackey, this seems pretty straightforward, did Judge Mackey make a finding that the litigation was frivolous from the outset or became apparently frivolous during the course of the litigation? During the course of the litigation, it became, apparent to him. That's what I want to know, is whether or not he made that finding or whether that's what you're urging because that's the way you would have us.
No, he made that finding because if you look at his judgment, and if you look at his order granting fees, August of 2019, he's specific about that. He says this lawsuit was frivolous, it was unreasonable, and it lacked foundation. Those are his words that he signed off on. So do we now second guess what this judge said and what he observed at the trial level? I don't think that that's what we should be doing here.
It's the question of the import of this part of Judge Mackey's statement of decision was contested at the Court of Appeal, correct?
Yes.
And the Court of Appeal did not address those particular challenges to the frivolousness finding because it concluded that no finding of frivolousness was required under the statutory standard in any event, correct?
Exactly. Judge Wiley said the statute is simple. It says what it says, and it means what it means. So to Justice Wiley, he didn't have to get to the second question, was there a finding of frivolousness, because in his eyes, the statute means what it says.
But you understand I think the subtext of my colleague's question is, we're just here to figure out what the standard of review is. The focus on, that's what we need to figure out. The focus on, did the trial judge make a finding of frivolousness, is essentially an argument that even if you're wrong about the applicable standard of review, you should still win on remand. But that's not, that issue's not before us, right?
Well, Judge Mackey made comments during the closing arguments and findings and used words that the plaintiffs were shields for the developer. And he also said that this was a sham.
But what does any of this have to do with the pure legal question before us? That is, what is the applicable standard?
It should be the Travis findings that, other than the judge having the discretion, okay, there shouldn't have to be a finding of the action being frivolous or unfounded or unreasonable. But we have that here, and As a side note, Judge Mackey also found that the respondents were entitled to their attorney's fees under Code of Civil Procedure 1021.5. That's not really argued here today. We're focused only on 91,003, but that is part of his findings and that's part of his order. Okay.
Mr. Colin, thank you. Your time's expired.
All right, thank you.
Ms. Shumener?
Thank you very much. Thank you very much, Your Honors. I will start off with Hedgecock and the standard that was established by Hedgecock 36 years ago. In interpreting Section 91003A, Hedgecock made it very clear, for the reasons articulated, that the standard must be that a prevailing defendant has to show that the action was frivolous in order to recover attorney's fees. That precedent was followed for 36 years. The legislature had 36 years in which to rewrite the statute to put the plaintiffs and the defendants on an even playing field, and the legislature never chose to do so. So to argue that the Political Reform Act has been around since 1974, yes, it has. And the legislature has had decades in which to consider the issue. And Hedgecock, frankly, brilliantly carried out the legislative purpose of vigorously enforcing the Political Reform Act, and did so in a way that it expressly articulated that it wanted private citizens to do so. If a private citizen happens to make a mistake in bringing a political reform action, and is then faced with hundreds of thousands of dollars, millions of dollars in legal fees and costs, we will not be carrying out the mandate of the legislature. The legislature, just as in Christiansburg, where the U.S. Supreme Court found that Congress intended to use plaintiffs as its weapon to enforce the Civil Rights Act, the California legislature expressly articulated in 81002F of the Government Code that plaintiffs, the private citizens, should be given mechanisms to vigorously enforce the Political Reform Act. And to adopt a standard, the Travis standard, will most assuredly undermine that objective. And the Hedgecock standard, which has been enforced for so many decades, there has not been a single flaw found in it that I detected. As for the frivolousness, and it dovetails into this policy to some extent, and must be looked at very seriously, because if Ravel, the defendant, the plaintiff's expert, was so compelling and so convincing, the case should have been dismissed when the plaintiffs rested their case. Ravel testified in plaintiff's case, not defendant's case, and the case was not dismissed. If we use hindsight as the measuring stick for a finding of frivolousness, it is no different than if we put plaintiffs and defendants on an equal footing, say he who prevails gets attorney's fees. It will very, very seriously undermine the legislative intent. And I would state, I can't state it enough, the Political Reform Act is vital. It is vital, and the legislature found that it was vital. And the simple fact that the plaintiffs couldn't afford to pay their own legal fees is neither a basis to punish them, nor to call them names, nor to award attorney's fees against them. It is not any evidence of frivolousness. Thank you very, very much.
Thank you, Ms. Shumener, Ms. Zimmer, and also Mr. Colin. The matter is submitted.